Abusia abeto dwa ene anope ya ekika court 12 mu ho ena Accra High Court edibetu dwa say chama Wontumi case a eja yeri akodan court efa Samurai boy case no ho say wase Ghana nsase na wabowra ekwayem wanfa mra kwan so ena wotu fam gudie ewo Ghana ekwayem no ene na court etena asem no so kura odi atemu aba na de afiri mu ba nyina ene say chama Wontumi okoko da fiase enfrihia mako eduonu 20 years onsenya dwumaden ka ho yasa twaska edi atuni tri so a ne nyina kyese enya asem ketua kura chama Wontumi odine hu bia enye ebusia yenkoe na yembo nwem na yenkohwe de si wo court ho ne senior judge ne no edi atemu ne atudwa na yenhwe de wi asem no esikoye wo court ho.
And as we know it, news just coming in, we know now that Chairman Wontumi will be going to jail for 20 years. Let's go to the Accra High Court now and speak to my colleague Fatal Bayaga, who is currently there to give us the very latest on this. Fatal, brief us. What is happening in the court now?
Mami, basically the court is done declaring this particular crucial judgment here this morning, and in fact the arguments in court were very interesting, but want to hear from the aide of Chairman Wontumi, who himself has always been coming to court with him almost every time. We just want to get a few words from him. He doesn't want to talk to us, but we'll try as much as possible to get a word from him at this particular point. He's been crucial supporting Wontumi in almost every time that he comes to court, but he doesn't want to engage the media. Clearly, from his demeanor, he looks quite disappointed at this particular point, knowing that his man is going to prison at the moment. But let's try and see if he would say just a few words here at the High Court after Judge Audrey Kokovite delivered this judgment just a few minutes ago. It took more than an hour reading the judgment here. And Mami, in Criminal Code 4, the whole process began when Charles Boache, who was in court holding the brief of Atachia, and basically on his feet, moving the motion. I mean, basically explaining that they are in court today in order to inform the court about the fact that they filed a motion for a deferment of the judgment because they were seeking the constitutional interpretation of some provisions of the Minerals and Mining Act, and they say that if these provisions are not interpreted properly, it means that their client will not be sentenced fairly. But the court dismissed that particular motion. Another thing that happened in court was that the lawyer also informed the judge about the fact that Atachia is currently out of the jurisdiction, and for that reason they would pray to the courts for the ruling or for the motion to be moved to a day after Wednesday, 22nd July. But the judge simply dismissed that as well, and in her view in the court, she basically said that Atachia was in court the last time when the court sat, and in fact he initially prayed for more time for him to familiarize himself with the case, the proceedings that went on before he took over this particular case. The court granted him that particular time, and that Atachia was well aware that the court was going to deliver this judgment. He should have told the court that he wouldn't be around today, but he never did that. And in fact, according to Audrey Kokovise, an experienced lawyer judge here at the High Court, she said if Atachia had told the court that he wouldn't be around today, then the consultations would have gone on, and in order to set an appropriate day for this particular judgment to happen, but he never did that. So it was incompetent, it was smooth lawyers or for Atachia to even write to the court and telling the court that he wouldn't be around today. So the judge simply dismissed that particular letter as well, and then went on to read the judgment. It took more than an hour basically reading this particular motion, and when she read the motion, the judgment at some point, she clearly said that based on the evidence adduced by the prosecution, Chairman Wontumi was found guilty in the charges that were slapped against him. And the prosecution called 4 witnesses. The defense, that's Wontumi's lawyers themselves, also called 5 witnesses, including Chairman Wontumi himself today, and the judge basically said that the prosecution was able to adduce sufficient evidence that meant that Chairman Wontumi would be convicted. When she was done reading the judgment, basically, so once she was done reading the judgment, the counsel in court today, who was holding the brief of Samuel Atachia, Charles Boache, was on his feet, and he sought litigation. He sought to mitigate the process, in order for the court to reduce the number of years that Wontumi would get at this particular point. He did that. He was so nervous whilst trying to plead the court to reduce the number of years. His hands were shaky in that particular process. He did that after a few minutes, and then another person who also rose on his feet, he also mentioned the fact that he wanted to explain to the court that Chairman Wontumi has a lot of businesses, and for that reason, if Chairman Wontumi is eventually sentenced to so many years, that could affect all of that. But let's listen to one of the lawyers who was in court today, just to appreciate what he makes of this particular process.
We are around that, because yes, I do appreciate that. Yes, there are situations where the veil of incorporation could be lifted and directors could be held responsible. It is not in all situations that those things are applicable. So I'm sure it's an area his lawyers would have to look at and see if it will open up some areas of appeal for him. But I'm a bit worried and a bit sad.
20 years for an offense that the minimum is 15, maximum 25. The judge, I think, might have listened to your plea, don't you believe?
Probably she did, probably she did not. Because I was of the view that the minimum sentence was okay. Because I made a point that getting Wontumi out of the picture, that is incarcerating him, may affect a lot of things, especially his businesses, the number of people he employs and all that. So that was the appeal I was making to the court, that yes, the court has come to the conclusion and convicted Mr. Wontumi for all the offenses. But in terms of the sentences, the court ought to consider his significance in society, especially the chain of businesses he owns. And I also made the point that currently we are struggling with a lot of youth employment. And if the court itself has established that Mr. Wontumi is the directing minds of all his businesses, it means it's very crucial to his businesses. So getting him away from his businesses in giving him such long sentence may negatively impact on the businesses, and the young people who get jobs through his businesses and all that, they'll come onto the streets as unemployed, adding to the huge numbers who are already on the streets with no employment. So that was the appeal I made to the court, that the court should consider this particular circumstance of Mr. Wontumi and probably give him the barest minimum of sentence. That was what I did. I don't
argument that it should be as a deterrent sentence to persons, especially the fight against illegal
considering
mining.
the way
you see, I am not in any way encouraging anybody to go into illegal mining. And for me, the point I was making is that yes, Mr. Wontumi may have committed the offense, but it was the bigger picture I was looking at, because he was going to be sentenced anyway. So my mitigation was to reduce the sentence. That's all. It's not to put in a defense for whatever he might have done or not. Exactly.
What is your relationship with Wontumi?
I thought he would have been given the barest minimum.
What is your relationship?
I don't know him from
Wontumi?
Anyway, probably we just share a name. I'm Bernard, he's Bernard. I have no relationship with Mr. Wontumi. Maybe because he's my namesake. But I only felt that as a lawyer, these things happen. It's not because it's Mr. Wontumi. There are times when you are in court and you feel like you need to probably intervene as a friend of the court. It is something we do out of ordinary practice. It is not because it was Mr. Wontumi. We have done this several times where we believe that we need to add our voice in mitigation. Remember, it is not against the conviction. It was just to intervene with the number of years he was going to be given. So it was against the sentencing that we were trying to mitigate, that the court should give him the barest minimum. It was not against his conviction. So it is not as if I did that to probably encourage illegal money. No. It was just for the courts to understand that Mr. Wontumi is just not like you and myself. He owns a lot of businesses. So the court, I don't know if she considered that, but well, I'm sure his lawyers would advise him accordingly.
So that's Bernard Oredu.
Bernard Oredu there talking to the press at the Accra High Court. Basically, he was one of the lawyers who was on his feet in criminal court and in fact, in his arguments in court, he told the judge that Wontumi has so many businesses and that if his sentence, if the years are too many, that could cripple some of the businesses, and many of the people who are currently employed by Chairman Wontumi's companies may lose their jobs, among other things. But the judge, in her, concluding part of the judgment, said that this is to serve as a deterrent to other people who are currently, involved in illegal mining, and went ahead to give Wontumi, or to sentence Wontumi for 20 years. But it was very interesting, Mami, in court today. In fact, Wontumi himself, in the process of the judgment, whilst Audrey Kokovite was reading the judgment, so he was clearly, shaking his head repeatedly in apparent disapproval of some of the things that the judge was talking about, and he was also consistently looking at the people who were sitting in court and basically, laughing and all of that.